We'll give it a couple of seconds before we get started while we have people come into the Zoom line. We still have people coming into the Zoom room, so we'll give it a couple more seconds to get before we get started. Okay, let me welcome everyone and thank you for joining us today. My name is Mohsen Manesh, and I'm a professor and the Associate Dean for Faculty, Research, and Programs here at the University of Oregon School of Law. And it's my great pleasure to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspectives series brings the work of our faculty to our colleagues, our students, our alumni, and to the broader public. Today's session is the final session in our 2026 summer webinar series, and it is entitled The Federal Tribal Relationship in Practice, Trust Responsibilities and Current Indian Law Developments. I'm pleased to introduce our two featured speakers, Chuck Sams and Howard Arnett. Mr. Sams is currently the Oregon Tribes Scholar in Residence at the University of Oregon School of Law, as well as a senior fellow in the Native Environmental Sovereignty Project. Sams served as the National Park Service Director under the Biden administration and was the first Indigenous person to serve in that role. He is Cayuse and Walla Walla and an enrolled member of the Confederated Tribes of Umatilla Indian Reservation, with blood ties to the Kokopah tribe and the Yankton Sioux of Fort Peck. He has more than 30 years of conservation experience and has worked in tribal and state government, nonprofit natural resource management, and conservation leadership. He is also a U.S. Navy veteran. Professor Howard Arnett is a 77 graduate of the law school, and he is now a professor of practice at Oregon Law, where he teaches American Indian law, tribal courts and tribal law, contemporary issues in American Indian law, and comparative law of indigenous peoples. Currently a partner at Carnop and Peterson LLP in Bend, Oregon, Professor Arnett has practiced law for over 40 years in Arizona and Oregon. His work includes representing tribal governments, tribal members, and Native American organizations on treaty rights, tribal sovereignty, tribal law development, government relations, water rights, and gaming. He is the 2016 recipient of Oregon Law's Meritorious Service Award. Sams and Arnett will examine some of the most consequential issues in contemporary Indian law, from the rapid rise of prediction markets in gaming to pathways forward for federal tribal co-management of public lands in challenging times. For more information on either of our speakers, please visit the Oregon Law Perspectives website. The plan for today's webinar is for our presenters to each speak for about 20 to 25 minutes and then to take your questions at the end of the two presentations. If you have a question, please feel free to use the Q&A feature on the bottom of the Zoom bar. Only the panelists and I will be able to see the questions, and they can be anonymous if you so choose. We will gather your questions and attempt to get to as many of them at the end of the two presentations. For those of you who are seeking CLE credit, you will receive an email after the event requesting your bar number so that we can report your attendance back to the Oregon State Bar. With that introduction, please join me in welcoming our two speakers.
Well, thank you, Mohsen. Appreciate that introduction, and it's always a pleasure to be co-teaching with Howie. Good afternoon, everyone. I hope you all are having a good day, and those of us in the Pacific Northwest, as we're trying to get through the smoke that we're all experiencing. Let's see here. There we go. Today, I want to talk about a path forward in challenging times with federal agencies and the tools for consideration, really exploring what mechanisms tribal governments and tribal nations can do, especially in relation to public lands. As many of you know, this administration came in very quickly with a number of both executive and secretarial orders that have greatly shaped about what we're looking. Currently, there are several secretarial orders I'd like to bring your attention to. Secretarial Orders 3426, ensuring national parks are open and accessible, which came out in April of 2025. It's intended to ensure that all national parks and national historic sites remain open and accessible for the benefits and enjoyment of the American people. This gives an opening for tribes to come in and help participate in the management of national parks and historic sites in a multitude of ways, anywhere from environmental restoration to actual visitor interpretation and support. It even specifically calls that out when speaking with the Secretary Burgum about this and how he wants to continue to work with tribes. His work as governor in North Dakota helps shape some of those ideals, and we'll talk a little bit about that a little bit later. Secretarial Order 3434, strengthen coordination with gateway communities, is another one, a policy to enhance coordination and strengthen partnerships in gateway communities. Many of the national parks are part of gateway communities that have tribal interest and or tribes themselves. And this is a great opportunity to figure out the economic portion of which tribes can participate in those gateway communities. Secretarial Order 3435, Expanding Public Lands Outdoor Recreation Experience Act, is the framework for fully implementing and maximizing the Explore Act. Tribes also play a part in that, both from an economic standpoint and from an opportunity to do public land management within and around parks. In 34th and I should say U.S. Fish and Wildlife Lands, Bureau of Land Management, U.S. Forest Service in some cases. And the Secretarial Order 3438, managing federal energy resources and protecting the environment, optimizing the use of lands under the direct management of federal lands by considering when reviewing a proposed energy project under NEPA, a reasonable range of alternatives, including projects and capacity density. This actually is one where I think the tribes need to be more concerned about, especially on how their commenting periods have shortened greatly around the NEPA process. But it's also one where tribes can have direct influence to ensure that they're protecting those resources that can be best managed by them, but more importantly, how those resources, if they do get exploited, what will happen to them and who will be the beneficiaries in the long run. Secretarial Order 3442, the Land and Water Conservation Fund implementation, it coordinates in the implementation of the department's use of the funds from Land and Water Conservation Fund Acts as amended by the Great American Outdoors Act, focusing on the implementation and execution of LWCF grants and acquisitions of federal lands. Tribes have really had to work hard to even be part of LWCF funding. When I served as director of the National Park Service, we were attempting to get at least 10 million of those dollars set aside for acquisition for tribes to use in acquisition of their homelands. That did not happen. This still offers a path forward to engage with tribes in a more meaningful way that through the Secretary's office on how you could get access to land and water conservation funds without having to go through states directly and being a recipient of those funds. Secretarial Order 3447, expanding hunting and fishing access, removing unnecessary barriers to ensuring consistency across the department's land and waters. DOI's longstanding commitment of expanding high-quality hunting and fishing opportunities for the American public while ensuring responsible stewardship. Well, this is an important one. And I would direct you to the American Bar Association's magazine that's come out, Natural Resources and Environment. There's a really good article in there that talks about the rights of usual custom rights of hunting and gathering in usual custom places, especially for tribes who have exact treaty rights to that. And the argument that places like Yellowstone, where those rights have not been extinguished by Congress, could have provide avenues by tribes to be able to get back into hunting and fishing. As we know, once they've started to expand into their hunting and fishing rights on public lands, it's also a way forward for them to start managing those resources as they have since time immemorial. Secretarial Order 3450, honoring our commitment to protecting Indian country's communities. The order continues to honor America's trust responsibility to Indian tribes by establishing the Indian Country Violent Crimes Task Force and other public safety enhancements within the Bureau of Indian Affairs Office of Justice. This is another one that actually goes through that not only are you protecting and able to talk about crime prevention against women and other people who may be subject to potential horrific crimes, but it also gives a gateway to work on the public lands and policing those lands, which then gives you an opening for your fish and game officers for tribes to also be able to go in and monitor public lands that are held in common with citizens of the United States. Now, what I really want to get into is kind of talking about what the federal tools are. By the end of the 20th century, as we all know, tribal governments and Native people worked to reassert their sovereign rights and better fully the obligations that they've had since time immemorial. Many of us call that creator's law in the Indian country. Today, tribal co-stewardship marks a pivotal shift in how land, water, and vital resources are managed by the United States, the states themselves, and tribes altogether. This approach centers on a meaningful inclusion of indigenous nations to the stewardship of their ancestral lands, often intersecting with public lands administered by the federal and state government agencies. The federal government defines co-stewardship as, and I quote, collaborative or cooperative stewardship arrangements that are undertaken pursuant to federal authority that requires the delegation of some aspect of federal decision making, end quote. When initially presented with this plan for co-management during the Biden-Harris administration, the Department of the Interior and White House solicitors' initial approach was to call this a novel legal theory. It took several Native appointees, all legally trained, to point out where federal authorities have either been shared with states or outright been fully transferred to them, by example, water law in particular. It was quite amusing to a number of us of the Native appointees and Native career staff that there was a lack of acknowledgement, once again, that tribes were stewarding these resources for thousands of years before discovery by European powers or the formation of the United States. It thus demonstrated that this partnership model must be rooted in respect, reciprocity, and recognition of tribal sovereignty, indigenous ways of knowing, and traditional ecological knowledge. It thus demonstrated that this partnership model could continue forward, but we must continue to emphasize the key principles of tribal co-stewardship and co-management has to include a respect for tribal sovereignty, a recognition of traditional knowledge equal to and sometimes vastly superior because of that 30,000 year experience of how it can be applied in management of public lands, a shared governance approach, cultural continuity for the tribes who have been stewarding these lands for generations, and what restorative justice can bring to the table when negotiating these co-stewardship and co-management agreements. Legal frameworks have evolved through, of course, statutes, executive orders, and memoranda of understanding. The most notable milestones include the National Historic Preservation Act of 1966, which is currently being up for review. And tribes should work to comment on that in order to protect their cultural and natural resources and the rights that they have secured through treaty or executive order in those protections. The Tribal Self-Governance Act of 1994 and the actions through the Department of the Interior by Secretarial Order 3403 in 2021. Increasingly, bureaus such as the National Park Service, the Forest Service, U.S. Fish and Wildlife Service, and the Bureau of Land Management are entering into formal agreements with tribes to co-manage lands and resources. Together, we thus serve all of the American people. The fight for social and environmental justice can be met through cooperation and building trust through relational actions and not transactional actions. Most of my work has been trying to build stronger relationships between federal agencies and tribal governments and less transactional. And even though there's a rotating, as I've been a political appointee through, the important is building those relationships with those long-standing federal staff who continue generation after generation, just as we have staff within tribal governments who do so. And attorneys can play an important role in figuring out how to negotiate those relationships. By the end of the Biden administration, over 400 co-stewardship and co-management agreements have been signed and executed across the Departments of the Interior, Commerce, and Agriculture. As the director of the National Park Service, I came into a bureau that had just a handful of these types of agreements, 6 to be exact. And by the time I was sworn in as the 19th director, almost exclusively, these 6 had been mandated by congressional acts that had created specific units of the national parks and historic sites. By the end of my time with the National Park Service, we had 159 signed agreements with over 50 more pending. As I understand it today, an additional 4 more agreements have been approved by the current administration, and I would argue largely due to the Park Service staff who were willing to fulfill their oaths of office to uphold and protect the Constitution by being good trustees to tribal nations, but also by the work of tribal leaders and their attorneys to ensure that they are exercising their rights to usual accustomed places to protecting of public lands. Across the country, tribes and their partners have developed diverse models of co-stewardship. By example, the Yurok Tribes Partnership at the Redwoods National and State Park, the Bears Ears Intertribal Coalition in Utah, and the Karuk Tribes Collaboration of Fire Management in Northern California are powerful examples of indigenous leadership in conservation and restoration. The benefits and challenges of tribal co-stewardship offer a wide range. by enhancing ecological health, biodiversity conservation, cultural revitalization, and of course, developing those stronger partnerships. Yet, we also continue to work around restorative justice because the challenges persist in the bureaucratic inertia, capacity limitations, legal ambiguities, and the need for trust building and public misconceptions that continue to run rampant. The path forward requires expanding partnerships, engaging young people, teaching the next generation of good stewards, all the way from kindergarten to postgraduate school, learning from international models, and reforming policy and integrating traditional ecological knowledge with Western science together. I want to highlight several tools and examples that you see before you right now. Co-stewardship agreements. They are the formal and informal arrangements between tribes, federal and state agencies to jointly manage land and water resources. As I said, by the end of 2024, at Interior, Commerce, and Agriculture, we had over 400 such agreements, each very unique, but they had a commitment to shared governance of public lands. And that shared governance model is extremely important in understanding who's responsible for what within that public land project. More importantly, though, what I saw is it became a force multiplier by bringing tribal entities onto the public lands and using their natural and cultural resources staff to get projects done. Tribal attorneys played a key part in understanding the nuances of what legal statutes needed to be put in place in order for the agreements to go forward. And then, of course, then we move on to 638 contracting. The Indian Self-Determination and Education Act of 1975 marked a turning point, empowering tribes to administer federal programs and services. Today, 638 contracts are used by hundreds of tribes to exercise self-determination and manage resources directly in the recovery of salmon in the Pacific Northwest, condors in California, bison from New Mexico to Montana, and fire management by the use of traditional burns from coast to coast. 638 contracting plays a pivotal role, and just that as contracting, continue to rely on our tribal attorneys to help us work through those nuances and ensuring that those contracts are firm. Self-governance agreements. Expanding on the ISDEAA self-governance agreements recognize tribes' greater control over program design and funding. The restoration of the U.S. Fish and Wildlife Bison Range in Montana to the Confederated Salish and Kootenai tribes stands as a landmark example of a successful tribal management and perseverance in part of a self-governance agreement. Contractual commitments and federal trust obligations. The federal trust obligation, rooted in treaties and the Supreme Court decisions such as the Cherokee Nation versus Georgia, requires the government to act in the best interest of tribes. The Red Lake Nation's recovery of the walleye fishery in Minnesota, achieved through collaboration and trust-based management, exemplifies the power and challenges of this obligation. Treaty lawsuits and consent decrees. Litigation remains a vital tool for protecting tribal rights. The Klamath tribe's successful injunction against timber sales that threatened treaty-guaranteed hunting rights demonstrated how legal action can uphold sovereignty and environmental stewardship. Land back initiatives and conservation easements. Efforts to return ancestral lands to tribes such as the Yurok tribe's reacquisition of Oru in California and the use of conservation and cultural easements are reshaping the landscape of tribal stewardship. The incorporation of treaty rights and fiscal statutes. Tribal consultation requirements, FERC licensing cases, and the defeat of environmentally harmful projects, by example, the Lummis Nation in opposition to a coal facility, illustrate how treaty rights are increasingly embedded in federal agency decision-making. And we continue to need to fight for that in this current administration. The Antiquities Act and the National Historic Preservation Act, the designation of Bears Ears National Monument and its shrinkages should be of strong concern, and the attack on Section 106 for consultation and co-management of these cultural resources highlight the importance of legal tools that need to be implemented to continue to protect sacred sites and promoting tribal leadership. State and local agreements. Oregon Senate Bill 770 and California Assembly Bill 1284 have established frameworks for state tribal co-management, requiring agencies to include tribal representatives in program development and implementation. This is a trickle-down effect from what the federal government is doing into state legislatures, and one that tribal lawyers need to keep an eye on and help tribes in shaping these bills as they come to the floors across the United States. And of course, the Alaskan Land Conservation Cooperatives, the Northern Latitude Partnerships in Alaska involving tribal governments and conservation organizations showcase innovative models for resilience and adaptive management, merging indigenous knowledge with Western science. And finally, environmental restoration and funding initiatives. Settlements like Oregon's $700 million agreement with Monsanto and the creation of the Oregon Environmental Restoration Council, which I'm honored to co-chair, provides direct funding to tribal environmental restoration, demonstrating the growing recognition of tribal interest in environmental justice. As climate change and ecological crises intensify, tribal co-stewardship is not only a matter of justice, but also a pragmatic necessity. By centering indigenous nations as equal partners in the care of land, waters, and wildlife, we honor their sovereignty, wisdom, and deep-rooted connection to place. We also become keepers. We also become the good stewards of natural resources. We all develop stronger relationships with the land. So let us, look, as legal scholars and advocates, commit to advancing Native American Indian law in ways that honor these principles. Let us work together to ensure that the next generation of leaders, many of whom are among you today, will carry forward the promise of stewardship, sovereignty, and justice. And most recently, two of those models have actually continued to move forward in case studies. One is the U.S. Fish and Wildlife Service's transfer of 680 acres of land to the Bureau of Indian Affairs to be held in trust for Spirit Lake Nation in Benson County, North Dakota. Originally, those lands had already belonged to the tribe, but back in 1959, they were transferred over to the White Horse Hill National Game Preserve to make hay for the bison. Since 1959, the tribal leadership has been fighting to get those lands back. Fortunately, last year they were able to have those lands finally returned to them and to continue to work cooperatively in the co-stewardship and management of the White Horse Hill National Game Preserve, which continues to propagate bison into the central United States. Additionally, the Yurok tribe's co-management in Redwoods National and State Parks, as of just this last week, 125 acres of ancestral land named Oru returned to the tribe in Oric, California via Save the Redwoods League. That partnership with the conservation organization, Land Trust, along with federal and state agencies, had returned land in the heart of the Redwoods National and State Park back to the tribe. And the tribe has already been working cooperatively on salmon restoration on a number of creeks within the national park and state park, along with the reintroduction of condors in partnership with U.S. Fish and Wildlife, and looking at how they can reform the watershed, both on lands that surround it with the U.S. Forest Service and those lands owned by other federal agencies. This multi-approach by the Yurok tribes serves as a great example of what can be done around both co-stewardship, but more importantly, co-management, where tribes are actually taking the lead in managing those resources on public lands. Well, I want to thank you all for listening to me today, and I look forward to your questions. And I want to turn it now over to my colleague, Howie Arnett.
Thanks so much, Chuck. And hello, everyone. And thank you, Mohsen, for the great introduction. It's a reminder to me that I've got to update my law school profile because my Ben law firm is no longer Carnot Peterson. It merged with a larger firm, Best and Krieger LLP. So that's my home now. It's in exactly the same location. So anyway, thank you. And let me screen share here if I can pull this off. If not, I'll get rescued by Jen. And let's see here. Get rid of this. And go from the beginning. Yeah, the title of my presentation is Indian Gaming versus Prediction Markets, and a quick little backstory. I've been doing this Indian Law Summer webinar for 5 or 6 years now, I think, and with Chuck the last couple of years since he joined the team here at the law school. And in January of this year, I started thinking about what am I going to talk about this summer? And usually it's Indian law cases in the Supreme Court, and there haven't been any this last term or the term before, which is pretty unusual. So I was puzzling about topics, and I suddenly started hearing about something called prediction markets. And I thought, what are prediction markets? And I started looking into it, and it became more and more interesting and more in the public view. And then I saw that there was a collision with state gaming agencies and Indian tribes over the sports betting space, which prediction markets have invaded. So that led to my topic, prediction markets and Indian gaming. And let's see here. This is uh, this is some of the early headlines across the country and across the world regarding prediction markets this year. The first was this New York Times piece, opinion piece in March, casino that's eating the world. We shouldn't want the world run by prediction markets. And this was March 3rd, and it was just a week or two after the U.S. launched the war with Iran. And the writer noticed people are betting on the date that the war with Iran is going to be launched and also aspects of that war. And then as time went on, more and more prediction market news made the national media. In April, this is after the Maduro Venezuela raid, a U.S. soldier who participated in that raid, the Special Forces Unit, was charged with a crime. He was charged after winning $400,000 betting on the removal of Maduro. And he's actually raising an interesting defense, which is essentially it's an insider trading. He knew the date because he was part of the planning. And so he won a lot. And his defense was there is no such thing as insider trading in the prediction markets space. So I can't be charged with a crime, and I certainly can't be convicted. And then more recently, there was a White House teleprompter operator who was discovered to have bet $100,000 on some of President Trump's speeches, which he knew what he was going to say and when he was going to say it because he's operating the teleprompter. And so that made the news. And he was making his bets on Kalshi, one of the prediction markets spaces or platforms. And the Maduro raid was on the Poly Market, another prediction platform. And then most recently, I saw in the High Country News, an environmental organization and newsletter and publication, which you wouldn't think would be talking about prediction markets. But then they discovered that people are betting on wildfires. And that became what's called the gamification of natural disasters. So what about sports betting? Let me get here. How are prediction markets colliding with Indian game? It's been a huge and very recent expansion of prediction markets into the sports betting space. If prediction markets stayed out of sports betting, we wouldn't be doing this webinar. I'd be talking about something else, but they've gotten into it. They call sports betting sports event contracts, and it makes up now about 80% of the prediction market's global trading volume. The big actor in this space is Kalshi. It's the dominant sports betting prediction market platform in the US. Second is Polymarket, and third is Robinhood. And these online sports betting platforms operate everywhere in the United States and globally. And the most recent World Cup event here in the United States and Mexico and Canada, and the telecast that lots of us watched, prediction markets were all over it. Kalshi spent 12.8 million on the World Cup soccer tournament TV ads. There was a famous, hilarious dentist chair spot with Timothy Chalamet, where he's in a dentist chair with his mouth full of dental apparel or dental devices, and the dentist is talking to him as they like to do when you're in that situation. And he's trying to answer the dentist's questions, and he keeps saying, Kashi, Kashi. He was trying to say Kalshi, and that's all it was. That was the ad, but you could soon figure out that he was representing Kalshi, and that was what he was trying to tell the dentist. Then, coupled with the very recent and huge expansion of prediction markets into the sports betting, tribes and states have also entered this arena. Sports betting has exploded in recent years and is now legal in 38 states, particularly in the last 3 or 4 years, plus the District of Columbia and Puerto Rico, and at many, many tribal casinos. In New Mexico and Washington now, sports betting in those states is only allowed in the tribal casinos. And in Florida, the only online sports betting platform is run by the Seminole tribe, their Hard Rock Bets platform. So it's an exclusive franchise for the Seminoles for online sports betting in Florida. And Kalshi and the other prediction market platforms, plus their alleged federal regulatory agency, the Commodity Futures Exchange Commission or Trading Commission, they're now embroiled in a massive wave of litigation in state and federal courts across the country with dozens and dozens of tribes, intertribal organizations, and states over the question of the legality of prediction markets operations in the sports betting arena. And we'll talk about how in a second how that came about. Let's see here. Background, first of all, on Indian gaming and sports betting. Most of you on this Zoom probably are somewhat familiar with Indian law, especially in the gaming arena. But it started in 1987 when the Supreme Court ruled in California versus Cabazon Band of Mission Indians that pursuant to traditional, well-accepted principles in Supreme Court jurisprudence of tribal sovereignty and lack of state jurisdiction in Indian country going back to 1832 and the Worcester decision, that applied to gaming, tribal gaming on Indian lands is free from state regulation, where the state permits some types of gaming. And that was the case in California and with this small Southern California tribe, the Cabazon Band of Mission Indians. A year later, this kind of had the effect of breaking a legislative logjam between tribes and states that had been pending in Congress for some time over who gets to regulate gaming on Indian reservations. Congress enacted the Indian Gaming Regulatory Act in 1988, and it embodied the Cabazon holding that tribal gaming is an exercise of inherent tribal sovereignty in the aid of tribal self-determination. And it set up this kind of elaborate structure for how that gaming will be operated. And a high stakes gaming operation that's called Class 3 casinos or Class 3 gaming in IGRA terminology. That'll be a tribal state partnership. But the statute also concluded that tribes have the exclusive right to regulate and offer gaming, including sports betting, on their Indian lands as a means of promoting economic development and self-determination. So that was 1988, but there's no sports betting yet. Then in 2018, the Supreme Court ruled in Murphy versus NCAA that federal law prohibiting states from authorizing gaming, it was the 1992 Professional and Amateur Sports Protection Act, which was essentially sponsored by Senator Bill Bradley of New Jersey, who was a former NBA star and collegiate basketball star at Princeton, that he was a sponsor of that. So there was no legal sports betting in the United States until the Murphy case got to the Supreme Court. New Jersey had passed a sports betting constitutional amendment to allow Atlantic City to offer sports betting, their casino there. And the NCAA sued the state. Murphy was the governor of the state, and that went to the Supreme Court. And the Supreme Court ruled that Congress can't do that, that the 10th Amendment was violated, the anti-commandeering grounds in the 1992 sports betting banning statute, which had the effect of leaving states and tribes to govern the region, the whole area of sports betting. That would be up to them to approve and regulate under state law and under the Indian Gaming Regulatory Act. So what about Kalshi? Little background on Kalshi and sports betting. Kalshi entered the sports betting space in January of 2025 and kind of stayed below the radar, but it didn't take too long. And the first case sued them in September 2025, followed by New Jersey, Arizona, Washington, New Mexico, and now a ton of other states, all asserting that Kalshi is engaged in unlicensed sports betting in violation of their state laws. Kalshi has now also been sued by tribes in multiple states for violating the Indian Gaming Regulatory Act and tribal laws governing gaming on their reservations. So this is Kalshi's position. It is exclusively regulated by the U.S. Commodity Futures Trading Commission. It's a federal regulatory body established in 1974 under the 1936 Commodity Exchange Act, the CEA, as amended most recently and critically by the 2010 Dodd-Frank Act, which gave the CFTC and the prediction markets exclusive authority over what are called swaps. And what Kalshi says in the other prediction markets, it is not operating a sports betting platform. It's selling sports event contracts, the price of which are determined by the market, which is composed of buyers and traders of yes and no contracts on the outcome of sports events. Kalshi charges a fee for each contract. That's how it makes its money, and it's making lots of money. Thus, unlike casino sports betting, and Kalshi keeps making this point, and sometimes it's making it successfully, sometimes not in court. Unlike a traditional sports book and sports betting, Kalshi's not the house. They're just charging a fee for the contracts. You're betting against other players and other participants in that marketplace. The contracts they call a type of derivative called swaps. And the contract buyers are betting essentially against each other by buying and trading yes and no contracts on the sports events, both game bets and prop bets. And in sports, a game bet is a variety of bet having to do to the totality of the sports event, the spread, the total points, the over under, things like that. It also sells and markets prop bets. Those are bets on the aspects of a sporting event, like how many points a particular player is going to score in a basketball game, or how many yards a quarterback is going to throw in a particular game. That's not doesn't depend on the outcome of the game. It just is an aspect of it. That's a bet. Most famous prop bet I can think of in recent weeks is in the World Cup, the final, Argentina versus Spain, where there were tons and tons of prop bets on the prediction markets made over whether how many corner kicks Argentina was going to get in the championship game. It turns out not that many, so many people lost money on that. Swaps are defined as contracts of sale of a commodity for future delivery. And under the 2010 Dodd-Frank Act, swaps are exclusively regulated by the CFTC. So Kalshi asserts, based on the Dodd-Frank Act and its exclusive jurisdiction to regulate swaps, under the Federal Commodity Exchange Act, as amended, preempts under federal law state and tribal gaming laws. That's their position. Let's see. The tribe's position. Let's see. Back up. I think. Let me give you the state's position first. The state's position on Kalshi and sports betting is there's no preemption. Sports events contracts are sports betting. They say it's just totally indistinguishable. And they're getting a lot of support, at least during the oral arguments in some of the circuit courts on that view. And as states argue, based on the Murphy decision in 2018, Supreme Court, laws regulating sports betting traditionally are left exclusively to the states. And that aspect of the PASPA commandeered the states from to regulate their own gaming interests. That's unconstitutional. So that underlines the view of the courts that sports betting and gaming generally is an activity that's left to the states to regulate. So their view is accordingly, and there's also a presumption against preemption in federal law. So their view is that under the CEA as amended by the Dodd-Frank Act, there is no preemption. State betting laws are neither expressly nor impliedly preempted, either through the theory of field preemption or conflict preemption. The tribe's position is different. And in many respects, and many would argue this, including Professor Kevin Washburn at UC Berkeley Law School, who wrote a great little piece on this in Law 360, the tribe's position is probably legally stronger than the state's position. They take the same stance as the state. Sports event contracts are sports betting. This thing about swaps and derivatives is just makes no sense. They're indistinguishable. And they say that the 2010 Dodd-Frank Act, the one that gave swaps exclusively to the federal agency to regulate, that's a general statute under the Commodity Exchange Act, which is silent about tribes. It doesn't say anything. And in Indian law, if there's a statute, general applicability that conflicts with a matter of sovereignty or other statutes which uphold tribal sovereignty, there's no repeal, there's no override or preemption, even expressly or impliedly. And in this case, it's the Indian Gaming Regulatory Act of 1988. Sports betting is conducted under that statute, and the Dodd-Frank Act and the generally applicable Commodities Exchange Act do not repeal or override that. They say nothing about Indian gaming or Indian law at all, and tribes in those federal laws. And federal preemption is also not a factor. And generally, federal preemption in Indian law is different than standard preemption. It's intended to be supportive of tribal sovereignty. So certainly the Kalshi argument of federal preemption wouldn't apply to the tribes. And in addition, tribes have some special Indian law rules that come into play and strengthen their position against Kalshi. There's a well-settled rule that a specific statute, like Indian Gaming Regulatory Act, will not be controlled or nullified by a general statute, like the Commodity Exchange Act and the Dodd-Frank Act as amended, regardless of when each statute was enacted. It's a landmark case, Morton versus Mancari, that stands for that principle. And finally, and maybe most helpfully, in Indian law, there are these things called canons of construction, which are rules requiring federal courts to interpret federal statutes in such a way as to benefit tribes. It's a sort of pursuant to the trust responsibility of tribes. So under that principle and that doctrine and the canons of construction, the Commodity Exchange Act, as amended by the Dodd-Frank Act, must be interpreted so as not to repeal or override the Indian Gaming Regulatory Act. And to the extent it conflicts with IGRA's grant of exclusive tribal jurisdiction over gaming, it must be construed liberally in favor of tribes and ambiguous provisions interpreted for their benefit. Supreme Court case on that is Montana versus Blackfeet tribe. So those are the cornerstones of the tribal position versus Kalshi, and it's strong, in my views, and Professor Washburn's view, stronger than the straightforward preemption argument, no preemption of the states. Now, there is litigation everywhere. It's now pending in 20 states in federal and state courts. These lawsuits either involve states and tribes in particular in California, New Mexico, and Wisconsin, suing Kalshi to enforce gaming laws or IGRA, or they sometimes involve Kalshi preemptively suing state gaming authority from enforcing state gaming laws like in Washington. Including some of the states like Minnesota who recently enacted statutes just this spring specifically prohibiting prediction markets from operating in the sports space. In addition, the federal agency, Commodity Future Trading Commission, is intervening in these proceedings aligned with Kalshi, or they're bringing their own independent lawsuits to support Kalshi's position against the states and the tribes. The remedy the tribes and the states generally seek is geofencing. Keep the platforms, keep your online platforms out of our reservations and out of our states. They would be prohibited from selling their sports event contracts in those jurisdictions. To date, 80% of the preliminary injunctions issued in these cases have been in favor of state tribes and against Kalshi. So that's the general lay of the land. But the first meaningful court decision is a Third Circuit appellate decision in which Kalshi won in New Jersey in April 6, 2026 decision, 2-1. It was the State Gaming Commission against Kalshi, and Kalshi won. The two of the justices on the three-judge panel agreed that it was preempted under state law. The dissent is really interesting. If you are interested, pull up that case and take a look at the dissent. Judge Jane Roth wrote the dissent, and she starts out by saying, I got on Kalshi. I pulled down the app. I looked at the Philadelphia Eagles versus Tampa Bay Buccaneers game, and I saw I could make all kinds of game bets, the spread, the total points, prop bets, yardage by each quarterback for each team, yardage by running backs. And that's virtually indistinguishable from ordinary traditional sports betting. And she called it a performative slight by Kalshi to try and draw a distinction. So elsewhere, here where the cases are pending and decisions are likely to come down soon. There's a Ninth Circuit case that seems to be at the front of the pack, Kalshi versus Nevada. Pending oral argument was on April 16th, and folks predict a decision coming down soon. And as I'll mention, the oral argument did not go well for Kalshi. Sixth Circuit, April 24th, Kalshi's motion for a preliminary injunction against Ohio pending appeal was denied. And oral argument in consolidated cases from Ohio and Tennessee was heard on July 29th, waiting a decision. Fourth Circuit, Kalshi versus Maryland, expecting a decision following oral argument on May 7th. Another Calshi case in the Second Circuit, New York versus Calshi, is pending. There's a second Ninth Circuit case, not one against the state like the Nevada case. This is tribes, three California tribes, small California tribes, suing Calshi in the Northern District, which considers the tribe's IGRA argument. So the IGRA issue is straight before the Ninth Circuit in this proceeding. The oral arguments have not gone well for Calshi. In the Ninth Circuit, in the three California tribes versus Calshi case, Judge Richard Paez said regarding Calshi sports event contracts, sounds like a bet to me. And sort of paraphrasing the dissenting judge in the New Jersey case. Also in that case, Judge Margaret McGowan said exempting hundreds of tribes from CET's exclusive jurisdiction wouldn't be so unreasonable. And this is in response to Kalshi's argument, hey, we can't have 200 or 300 or however many tribes there are in the United States that have gaming or have casino operations. We can't geofence all of those. That makes no sense. We can't possibly do this. And the judge said, why not? It wouldn't be so unreasonable. At the Fourth Circuit in Calshi versus Maryland, one judge memorably and remarkably said, if it quacks, it's a duck, right? It's gaming, isn't it? And then in the Ninth Circuit versus Nevada case, Judge Ryan Nelson said, this is sophistry to the nth degree. It's still the House regarding Kalshi's claim that prediction markets are different than casinos because you're not betting against the House. I don't understand how you can say those things are different, said Judge Nelson. So generally held view is that it's going to the Supreme Court, probably based on a circuit split, Third Circuit versus the Ninth Circuit, or maybe another circuit if it gets ahead of the Ninth Circuit, unless Congress acts. And that's the other thing we should consider. Legislation. There have been bills produced and proposed in Congress by Senator Merkley of Oregon to stop trading on predictions and Corrupt Bets Act, the STOP Act. Another bill introduced by Senator Schiff, California, Senator Curtin, so it's bipartisan. Of Utah, Prediction Markets are Gambling Act to keep sports and casino-style events off prediction markets. There was a Senate Indian Affairs Committee letter to the CFTC asking them to rein in prediction markets in the sports space. And they held a roundtable yesterday called Tracking Prediction Markets Exponential Growth. And I saw a report from some of those who attended that roundtable last night saying there is a proposal introduced or discussed at that roundtable about a possible amendment introduced by a New Mexico senator to the amendments to the Commodity Exchange Act via the Farm Bill, which is more likely to be must-pass legislation that would do just that. House Agriculture Committee is considering hearings and so on. The CFTC is now, of course, operated under a chair who's appointed by President Trump, is obviously sympathetic. They're bringing their own lawsuits in support of the tribes, but a previous chair of the commission said the commission has lost its way. That's not what the commission should be doing. They've got the wrong position on this. And generally, there's a nationally recognized sports attorney, Daniel Wallach, who said the politicized nature of this controversy, politics loom in the background when you consider the CFTC has only been suing states that have Democratic governors. It really highlights for me that there is a political component to this more than a legal or practical one. So, oops, stay tuned. There are new legal and political developments every day. Thank you, and I guess we'll open it up for questions.
Thank you, Howie and Chuck, for a pair of very fascinating presentations. We have a few questions in the queue. If you do have a question for either Howie or Chuck, please use the Q&A button at the bottom of your screen and you can submit it. And again, only the panelists and I will be able to see your questions. So let me go through some of the questions that we have already entered into the queue. Chuck, I think this first one is for you. The draft notice of proposed rulemaking introduces changes that narrow the definition of a historic property, specifically excluding non-compact, unimproved natural features like landscapes, and pivots public and stakeholder participation to a matter of agency discretion. Given how critical these features are to indigenous cultural sites, what are the panel's thoughts on how this shift from mandatory collaboration to agency-directed review impacts meaningful tribal input?
Oh, it absolutely does. I actually say that also smacks in the face of the trust responsibility that the federal government has when considering these. I'll be speaking to this at the National Historic Preservation Trust Summit next month to look at, what this decision, if it gets adopted, will really mean for tribal governments as a whole. There are a number of other scholars looking in and digging deeper, so I'm hoping to have a better assessment in the future. But my initial reaction is that, it just really does foreclose on the obligations that federal agencies have to tribes, but also to the general public, because you'll also notice that they're trying to eliminate and or greatly reduce public comment on these entire sections that we as the American public have a right to voice our concerns on, and tribes specifically on the lands that have been ceded to the United States. Howie, I'd also love your thought on that.
No, I don't think I have anything to add to that. That's good perspective, Chuck.
Okay, then let me go on to our next question. In the land back context, some native nations do not wish to have conservation easements attached to returned land due to sovereignty concerns and obstacles when putting land into trust land. However, there are federal requirements of perpetuity sometimes attached to conservation easements when landowners receive federal income tax deductions, and it might violate IRS tax rules to remove the easement. Are there any initial thoughts for how organizations performing land back transactions could handle altering conservation easements or extinguishing them or navigating co-stewardship when conservation easements are maintained?
That's very interesting. So there's a number of ways to get at that, depending on whether it's within the inside or outside the exterior boundaries of the reservation of the land that is being returned. It should be for consideration. When I did land trust work for a number of years, we did our best to extinguish those easements, but there'd also been a workaround of trying to figure out how to have those easements transferred to the Fish and Wildlife of the Department of Natural Resources within the tribe, or to that department itself, or to another department that could oversee those easement requirements. But you still ran into the issues with the Bureau of Indian Affairs if you wanted that land returned into trust, because they didn't want to see any encumbrances whatsoever on those lands. And so that became the tricky part that we still are continuing to work on and make arguments about with the federal agencies and with land trust organizations across the United States, because that still hasn't changed from the Bureau of Indian Affairs of taking the land into trust. So other ways of doing it is having the trans just take it into fee simple, but then using opportunities, each state being different, of being able, if the land is being used for educational purposes, to get it off the tax rolls, or for cultural purposes to get it off the tax rolls, so that then the tribes can manage it in the way that they see best fit moving forward. Howie, your thoughts?
Yeah, that's a good question and a tough issue. And I'm just finishing up a feeder trust transaction for Warm Springs right now.
Mhm.
The United States is absolutely a sticker about no encumbrances, and they want a title insurance policy that is completely free of any possible encumbrance. So that's a real difficulty. What about, Chuck, some sort of a temporal aspect to an easement? When Warm Springs was able to get Congress to restore lands to the reservation in 1972 that had improperly been denied from the original treaty reservation in 1855, they had an agreement in the legislation that federal access and public access to those lands for hunting and fishing, because they'd been part of the national forest before they were transferred to the tribe, can continue for 20 years. And after 20 years, it'll revert to the tribe, just like every other piece of trust land on the reservation. Does that open up a possibility of a temporal aspect to something like this?
I think it does, both on and off reservation. The Confederate Tribes Umatilla Indian Reservation have a very similar project. I think you might be aware of, Howie, and for those who don't, called Rainwater in Washington State. So we ceded those lands to the United States, but our headquarters of our tribe and our reservation is in Oregon. And so to extend that, though, when we purchased those lands, we did, I think it was a 10 or 20 year, trying to remember now, at least 10-year agreement that those lands would still remain open to general public use for hunting and fishing. So non-Indians being able to hunt on those 10,000 acres, but eventually that would be extinguished and then tribes would own it outright. And then we could make a determination moving forward about putting that into federal trust.
Yeah, yeah,
And
yeah.
so it is a temporal
Yeah, I
easement
think the
that met
bottom
all the
line is
requirements.
when tribe gets land back, it wants it to be like all of its other lands,
Exactly.
strings attached. We've got sovereign authority to govern these lands. We know how to do it. We've been doing it a long time. We don't need these strings attached.
Howie, a couple of questions regarding prediction markets. Um, One, can you explain how the term commodity can be interpreted to cover prediction market swaps? And then separately, what's the best venue in your view for resolving this open legal question? Is it through the judicial system and through the litigation that's making its way through the courts and maybe ultimately the Supreme Court, or is this an area where Congress needs to really step in?
Yeah. Uh, I don't know how you construe commodities to be swaps that include these contracts. I mean, the dissenting judge in the Third Circuit, she called that a performative slight. And the other justices who've commented at oral arguments said this is ridiculous. They're indistinguishable from traditional sports betting. You're just kind of making this stuff up. And what's going to happen at the end? Boy, I don't know. I mean, I think it would go to the Supreme Court with a conflict or a circuit split. Whether the Indian issue would be part of that, if it's the New Jersey case versus a California, Nevada case, and that might get sort of lost it's quite possible, legally speaking, if they proceeded in the right way, the states might lose and the tribes might win. And so there's geofencing and 250 reservations across the country, which Kelsey will scream about. By the way, Kelsey was ordered to geofence in Nevada in the district court. And the state of Nevada came back and said, "You're not. I can still get on your app and I can still do it. And I'm sitting in Las Vegas." And so Kelsey had to go tell the federal judge, "We're working on it. We're working on it. We're trying to geofence Nevada." But anyway, so probably legislation, to the extent legislation can ever get through this Congress or the next Congress, something that sort of tries to resolve this on there seems to be bipartisan interest in this. But the prediction markets, Kalshi in particular, are well connected politically and at the highest levels. And so how that plays out, we'll see. But I'm suspecting that ideally the resolution would be a reasonable common sense legislative solution. Because as you said, Motion, before we got on, it's a mess. Prediction markets are a mess.
Yeah, yeah. Next question from our audience. How can communities use collaborative federal tools like co-stewardship to protect local water from industrial and tech infrastructure strain, ensuring true watershed preservation?
That's a great one, and the federal government's already looking at it. So as we're looking at the changes around NEPA are happening and what this administration is pushing forward, I just had a conversation with a bunch of other law folks at Yale Law who are looking at, all right, we need to start shifting to the Clean Water Act. And then, of course, they're already looking at now the Clean Water Act and how can they extinguish tribes' rights and treaty obligations that the federal government has under the Clean Water Act. So it's a multi-pronged attack by this administration on a number of federal acts where tribes' treaty obligations are going to be attacked or try to be nullified. And so I think that the only thing we can do is one, figure out how to fight back. And the legal scholars on here and the lawyers on here working with their tribes, and then figuring out how to do so in a collaborative effort across a number of tribes, because both NEPA and the Clean Water Act are tools that tribes have been able to use to not only protect their treaty rights, but also to improve the environment greatly, including water quality, like such as the state of Oregon, water quality management based on salmon consumption. So there are mechanisms but they're going to be unique, I think, to each tribe, but there will be commonalities that tribes could band together in order to protect their treaty rights, especially in the West.
Howie, do you have anything to add to that one?
No, I think that was good. Chuck's answers are always great. So,
So I think we have time for one more, but let me get one additional one. There's a question. How can we get access to Howie's slides? I'm sure if you email Howie, you can find him on our website. He would be happy to share his slides with
yeah,
you.
sure.
And is that all right, Howie?
Yeah, absolutely.
Okay, great. And you could also review this whole webinar. We'll share it on our YouTube channel. Last question, and I'll throw it out to both of you. How can tribes effectively respond to the administration's efforts to specifically exclude incorporation of treaty rights in implementing federal statutes? I'm thinking of the proposed EPA rule to eliminate consideration of treaty rights when states develop water quality standards under the Clean Water Act.
Howard's been
Chuck,
practicing way longer on this than I have.
uh, wait out the administration.
Yeah.
Hmm.
I think a
Okay.
lot of it, I don't disagree. Part of it is waiting out the administration and just being prepared with your legal briefs on what
Yeah.
may the fight that's going to be coming down.
Yeah, well, that'll be litigation. If that gets in the final rule, that's going to be litigated,
It'll
and
be litigated.
federal courts will have something to say about that. That'll take some time.
Yeah, and one thing we see across the different areas of law is how durable any legal decision or tool is, given the swings back and forth among political administrations.
Yeah.
Well, that's all the time that we have for today. Let me thank everyone, and in particular, let me thank our two speakers for leading us through a thought-provoking presentation and discussion. And let me thank the audience for tuning in. This marks the end of our Summer 2026 Oregon Law Perspectives webinar series. We hope to see you again soon.
Thanks, everybody.
Bye.